Microphone number 1.
Chair, I'd like to reintroduce Mr. Michael Sanderson.
Hello
Mr. Sanderson.
I'd just like to build a bit on what Mr. Caulfield has just pointed out, but from the perspective of your customer, the consumer. It goes to the issue of access to justice when things go wrong and issues of disproportionate power. AFCA, Australian Financial Complaints Authority, is perceived by bank consumers to be a bias in favour of its members. Yet banks routinely claim that AFCA is independent and impartial. Some examples that the banks are wrong are: a former AFCA case manager, who I'll call RC, worked for NAB for 29 years before working for AFCA for 2 years. He then took up a position with Bank West. Just prior to leaving AFCA, RC found in favour of a Bank West matter as a case manager. Also, Gerard Brody of Consumer Action Law Centre, CALC, found that of all home lending complaints made to AFCA in the year 2020, there were no determinations that favoured the consumer. Also, in March of this year, 2020, an AFCA ruling was overturned by the New South Wales Supreme Court due to the absence of impartiality and independence. And I would say that if more consumers had access to the courts, that would be a commonplace finding. I personally know, as a complainant and as an ex-member of AFCA, that AFCA is biased to the point of corruption. And I don't say that lightly. Because there's no meaningful AFCA merits review of NAB cases, and other bank cases for that matter, outside the courts, is NAB prepared to consider funding a merits review of NAB AFCA cases in the federal court?
Well, I've never contemplated that, and if you want us to look at that, you can write to us and ask us that, and I can give it some thought. But certainly not prepared to commit to it today, no.
I'd like probably a little bit more focus. I'd like to write to somebody, because you don't write to an organisation.
You can write to Ms. Sharon Cook.
Ms. Sharon Cook, okay. I do have another issue here. I'll just flick through. Here we go. Regarding NAB risk going forward, with particular focus on the mandatory contractual warranty of the Code of Banking Practice. Does the NAB board acknowledge that NAB and its internal and external lawyers are mandatorily required to comply with Clause 35 of the Code? If not, why not? If so, is NAB aware of any occasion where its lawyers have not fully complied with Clause 35 of the Code in the past?
I'm sorry, I don't know the answer to that question, but I believe that we would comply.
Okay, and
you've asked about in the past indefinitely. I would have to be able to go back and do a review to answer that. I have no idea.
Okay, the mandatory Code of Banking Practice states that disputes handling will be free of charge and meet the standards set out in the Australian Standard AS 4269-1995. Just for information, you've got to buy that standard. It costs you $170 to buy an Australian standard offshore. I just find that perverse, but it features in the Code of Banking Practice. And, my understanding that while in dispute, NAB also uses its credit issuing powers and routinely issues additional credit to some borrowers and charges them interest to pay for their lawyers. So effectively what they do is they issue credit to the loan account to pay the lawyers. I experienced this in my case with Bank of Queensland. The Bank of Queensland netted $115,000 from a farm they valued at $900,000. When the legal costs reached $115,000, the Bank of Queensland wrote off the debt and discontinued legal action. Yeah, I understand from that point the Bank of Queensland would have had to use their own capital to continue. Apart from the obvious abuse of the bank's credit issuing powers, can NAB explain how this is not a breach of the code and the standard? And would NAB agree that such a practice is an abuse of power, which further amplifies the inequity or equality of arms in the court?
Is that the extent of the question?
That's it, yep.
Thank you. Thank you. Well, I can't provide any answer to any of that question. You've asked me a hypothetical as to whether something would be a breach. If it was set out that way, the way you've described it, that's probably the case. But I have no knowledge of the underlying facts you're talking about. So perhaps we can go to the next question. Thank you.
I'll just make a comment that the fact that you're unable to answer the question obviously demonstrates a disconnect and lack of knowledge of what's actually going on out there.
Look, I appreciate that you sit there and prepare a very convoluted hypothetical question, but I'm just not in a position to answer questions like that.
That's right. Is there a possibility to talk again?
You can provide those questions in writing. You can come up to us and ask us afterwards. In fact, the sooner we get through the questions, the sooner we'll be able to come and have conversations with our shareholders.
Okay, thank you.